Good morning. Welcome to the Senate Judiciary. See, I've already messed it up. Well, it's the Senate file today. So, welcome to the Judiciary and Public Safety Conference Committee. I'm Senator Ron Latz. I'm chair of the combined Judiciary and Public Safety Committee, Budget and Policy Committee in the Senate. Because it's a Senate file before us today, I'll have the gavel today, and per the rules, we'll be alternating. I would like to welcome everyone who is here at the table. In a moment, we'll give everyone a chance to introduce themselves so we all know who we're sitting here with. And then we'll give some time for each of the chairs to make a couple of introductory remarks. And we're going to then invite each of the three commissioners to come forward just to introduce themselves. And then from there, in terms of getting into the substance, we're going to ask the House members to make some presentations on the bills that they are bringing into conference that we do not have on the Senate side. So this is an opportunity for the senators to get educated as to what is being presented and why we should consider including them in the final product here, or this week, or whenever we can get finished. In terms of timing, I'm anticipating that we will go conference committee until just about 12:30. We'll take a break for lunch. The Senate has session at 2 o'clock today, but it should be fairly short. And then we can reconvene after that as time allows, and if we have the work ready to do. We don't have all the side-by-sides prepared yet. It's just been the compression of staff time and the revisor's office, and a lot of product coming through the pipeline, as we have all dealt with all session long, which is exciting, but it becomes a little bit more challenging administratively. I, for one, am very excited to be on the cusp of what I think are historic investments and policy changes in Minnesota. And I'm confident that we are going to end this conference committee with a product that we can all be proud of in that regard. So with that, I think maybe what I will do is just do a brief introduction of myself. I'll turn it over to my colleagues, the chairs, to introduce themselves, and we'll go all the way around the table, including staff, so everyone knows who the staff are as well, and then we'll go from there. I am back in the House building here. I started my legislative career in the House after serving 9 years on the St. Louis Park City Council. I spent 4 years in the House and was elected to the Senate in the election in 2006. And I have been in and out of the majority, just like I was in the minority the entire time I was in the House. You guys, the DFL took the majority the year I left. So I'm not sure if there's any symbolism to that or not, but we won't open that for discussion. I've served on the higher ed committees, commerce committees, education policy committee when I was in the House, and a few other committees along the way, but because of my own professional background, I have gravitated or been pulled toward judiciary and public safety issues. I'm a private criminal defense attorney, and I do plaintiffs' employment work as well as some general civil litigation. I've got a private practice in St. Louis Park. Like probably some others in the room, I worked in the Attorney General's office as an Assistant Attorney General for 6 years in the Human Services and then in the Public Safety Division, where I prosecuted driver's license revocations out of the DWI-related cases. Yes, I'm a former prosecutor, counterparted with the current Assistant County Attorney and defense work on my background as well. And I do a fair amount of volunteer work on the misdemeanor defense panel in mostly Hennepin County courts now. So I'm basically in court, especially when we're not in session, 3-4 days a week. So that's a bit about my background. I'm married. I got 3 kids, 2 out of college, 1 ninth grader, 2 of them going into management consulting in New York, and the 9th grader still working on what she wants to do with her life. So with that, I think I'll turn it over to Chair Moller. Introduce yourself, and glad to be serving here with all of your members.
Thank you, Mr. Chair, and welcome to senators and staff. Thank you for coming over here today. We appreciate the opportunity to work together. So I am Chair Kelly Moller. I chair the Public Safety, Finance, and Policy Committee in the House. I'm in my third term. I represent District 40A, which is the northern Ramsey County suburbs of Arden Hills, Mounds View, and parts of Shoreview and New Brighton. When the legislature is not in session, I am a prosecutor, and I have done that work or victim rights advocacy work for over 20 years. And I was an assistant AG as well, and I did an implied consent rotation, although our time there did not overlap at all, so that was a fun fact. And like I said, I'm just really excited to be here today and get to work on these great bills. Thank you.
So Chair Jamie Becker-Finn, this is my second term serving as chair of the Judiciary and Civil Law Committee in the House, my fourth term here in the House of Representatives. I was staff way back in the day as well, so my years of service are a bit longer than even my 4 terms here. I represent Roseville and the other side, most of Roseville and the other side of Shoreview that Chair Moller does not represent, so we are the A and B side of Senate District 40. Have also worked as a prosecutor in Hennepin County, primarily in domestic violence cases. And then I also teach part-time at Mitchell Hamlin. I teach legislative process. It's like the one thing I can teach where I don't have to keep up with all the case law. I can just be here and then go teach people how we make laws. And then I am also a small business owner. I own Muckwa Coffee, a small coffee shop in Roseville. As far as the rest of my background, I grew up, so I'm Leech Lake Ojibwe. I grew up on the reservation, lived there my entire life until going to college, and I share that with you because growing up in a rural, really low-income area definitely impacts the work that I do here, and so I do think it's important to share that background as well. And then I have 2 kids who their mom has been serving long enough that they're kind of over it. And are bummed that I'm missing a lot of their soccer games during this last part of session. So, but happy to be here, and this is a much better setup than the last time I was on this conference committee. So, excited for the work we're going to do moving forward here. Hopefully, I think they're giving us a week, so be good to work together with everyone. Thank you.
Good morning, everybody. Cedric Frazier, District 43A, which covers the cities of New Hope and Crystal. This is my second term. This is my first term as vice chair of the Judiciary. In my first term, I was vice chair of Public Safety Committee, and I've had the honor of working under 2 great chairs, 3 great chairs in the time that I've been here. Originally born and raised in the city of Chicago, South Side community, Inglewood, and I think it's important to share that it's a poor working class community, and it does shape much of what I'm trying to do here on this committee and my work at the legislature. The father of 3 daughters, very proud of those 3 young women. One of them is only 9, so she is rising very quickly. She thinks she's a little bit older than 9. But a lot of the work I do here is about what their future will look like and what my grandchildren's future will look like. So very, very, very excited to serve on this committee and welcome senators to the House, and looking forward to working with you all. Thank you.
Representative Breon Curran, 36B. I represent Vadnais Heights, White Bear Lake, Gem Lake, Birchwood Village, and half of White Bear Township. I serve both on the Judiciary and Public Safety Committees over here on the House side. This is my first term. My background is in law enforcement. I was a 911 dispatcher, and I'm a former police officer. Outside of this, I worked in nonprofit disability services, so that's another aspect that's important to me, but glad to be here. Nice to work directly with the Senate for the next week or so, and looking forward to it. Thank you.
Oh, we have the House staff go ahead and introduce themselves. Well, a reminder to the senators especially, the mics are always on.
Oh, yeah.
Unlike in the Senate building where they're only on if you flip a switch, these mics are always on unless you push the button that says mute. I'm told it's not entirely certain that if you push mute, it will actually mute the mic, which is one reason that the House needs to have a big appropriation to fix all of their buildings and technology. But you should just be aware, side conversations could be picked up by the mic. You should assume that it will. Thanks. And speak right into the mic as well when it's your turn to talk. All right, go ahead.
Chair Latz, Chair Moller, I'm Ellen McDaniel. I'm the Committee Administrator for the House Public Safety Finance and Policy Committee.
I'm Anna Borgerding, and I'm the CA for Judiciary.
Ben Johnson, House Research Department.
John Walls, House Fiscal Staff.
Jeff Diebel, House Research.
Mary Mullen, House Research.
Zach Meinertz, DFL Caucus Research for Judiciary and Public Safety.
So let's go to the senators that have joined us here today. Senator Seaberg.
I'm Senator Judy Seeberger. I represent District 41 on the east side of the metro. It's the communities of Lake Elmo, Afton, the Lakeland cities, Cottage Grove, and Hastings. This is my first term as a senator. In my non-legislative life, I am a trial attorney, but I work on the civil defense side. So I don't do criminal work, and I work defending people and businesses who are sued in civil court. I'm also a paramedic. I ride 911 ambulance in North Metro, South Metro, River Falls, Lower St. Croix Valley. I'm on the fire department, so I have a strong interest in public safety as well. And because I still don't know what I want to be when I grow up, I have a teaching license. I'm a high school and middle school English teacher. That's actually my favorite job and something I hope to get back to someday. I have two boys. One is 19. He's just finishing up his freshman year. He comes home on Wednesday. And I'm looking forward to that. I miss my boy. And my little guy is 18, and he's a senior. He's getting ready to graduate. So I'm having a verklempt mother moment here as my babies grow. And they're awesome. I have a husband, too. Yeah. We've been married 20-something years.
Hi, I am Bonnie Westland. I am the Senator for Senate District 42, which is Plymouth, 1 precinct of Maple Grove, and the beautiful city of Medicine Lake. I am thrilled to be here. In my other life, I am a family law attorney and have my own family law practice. So I was definitely very interested in being on judiciary and public safety. And I am the proud mother of 2 adult sons, and I have 2 granddaughters. And let's see, what can I say? My younger son is currently at North Hennepin, going into computer science and hopefully transferring to the U at some point. My older son is director of customer service for one of the local airlines. I'm not going to say which one. But anyway, I'm thrilled to be here. It is wonderful to be surrounded by so many passionate and incredibly smart people. Not only my colleagues in the legislature, but our staff is the best. And so I'm glad to be here.
Good morning, everyone. I'm Senator Sandy Pappas from St. Paul. Welcome to my district. And many of you who are from out of town probably live in my district during a session. I am very happy to be here after the last 6 years in public safety and judiciary purgatory in the Senate. The last time I was on I think it might have been called the Criminal Justice Committee, was when I served in the House in the 80s. And we did amazing things back then. I remember that Minnesota was really ahead of the crowd in those days, and I'm hoping that we can get back into that position with this bill and the good work we're going to do over the next 3 years. I have represented my district since 1985, so I'm a real long-termer here. For some of you may or may not know, I do have 3 daughters all living in Israel. In fact, my husband is there right now for a bar mitzvah and a 6-year-old birthday party. I have 31 grandchildren, and I actually have 1 great-grand. Yeah, and I do have a husband. And we've been married 40-some years. I do not.
Good morning, everyone. I'm Claire Umu-Verbaten. I serve as the Vice Chair for the Judiciary and Public Safety Committee in the Senate. I represent District 66, which includes parts of St. Paul, Roseville, Falcon Heights, and Lauderdale. This is my first term. I'm really excited to be here. A few things to know about me. I'm really proud of my heritage and my full name. My mom is Senegalese, and Gave me the middle name Umu from my grandmother. My dad is a second-generation Dutch American. That's where Verbatim comes from. When I'm not serving in the Senate, I serve as the Minnesota State Director for the Partnership. We're a national organization that runs leadership development programs for professionals of color.
And our Senate staff.
Nicole Kaplan, I'm the Committee Administrator for the Senate Judiciary Committee.
Ken Back, Senate Counsel.
Chris Turner, Senate Fiscal Analyst.
Jackie Clinton, Senate DFL Research for Judiciary.
Diana Rico, CLA for Senator Ron Latz.
And we've been joined by Representative Feist. Go ahead and introduce yourself.
Am I the last person on this side? Cool. Well, thanks for letting me step out. My daughter's 5th grade class was on a tour of the Capitol today, so I had to say hi. So I'm the Vice Chair of Public Safety in the House. I represent 39B, which is the southern part of New Brighton, Columbia Heights, and St. Anthony. I live there with my family, my 5th grade daughter, and I've got a 13-year-old as well. I am an immigration lawyer when I'm not at the Capitol, and I'm also an adjunct professor of immigration law at the University of St. Thomas. And I am so excited to be on a conference committee because I've never been on one before, and really focused in the public safety realm around youth justice and all of the things we can do to more proactively, effectively support youth who get involved in our criminal legal systems. So very excited to be here with you all. Thank you.
Thank you all, and we'll do some introductions now from the commissioners, and I don't know if we have a representative from the courts with us or not, if Justice Gilday is here, or Jeff Shorba can come and just introduce himself as the court administrator as well. So we'll have all the branches of government appropriately covered. So Jeff, are you here for the duration?
You know, I love every minute, so I'm here for the duration. Jeff Shorba, State Court Administrator.
Okay. So we'll probably have people come down to the mics so that when this is recorded and the public is watching, so everyone knows. That was Jeff Shorba, just introduced himself.
You want me to come down?
Yeah, come on down and say it officially. I was a little informal with Jeff. Mr. Shorba, Jeff and I were law school classmates, so I had a hard time breaking out of that.
Happy to see the conference committee formed. I'm Jeff Shorba. I serve as the State Court Administrator for the Minnesota Judicial Branch. Happy to be here to answer any questions you have. Thank you.
Thank you, Mr. Shorba. Commissioners, come on down.
Good morning. Rebecca Lucero, Commissioner for the Minnesota Department of Human Rights. Thanks for having us today.
Good morning. Paul Schnell, Commissioner of the Department of Corrections. Super excited about this and looking forward to all the work that gets done and committed to doing whatever it takes to get through this.
Love the optimism. Is Commissioner Jacobson here with us? When 2 minutes, okay. Well, when he gets here, we'll give him an opportunity to say hello as well. All right, well then, let me just say a word or two about the process here. Some of us served on conference committees in the past when conference committees functioned like conference committees rather than as just back channel conversations. So it's my goal is to make this process once again a little more transparent, a little more publicly accessible, and make sure there's ample opportunity for stakeholders and those who are interested in what we're doing to participate and to know what we're doing. So for those who are probably newer than in the last 6 years, you probably haven't seen that. But we're going to try to do the best that we can to make that happen, understanding we are under a very ambitious timeline here. So we will probably not spend a lot of time on the same and similar reviews anyway. We're going to assume the public has paid attention along the way. The stakeholders have as well, and that information will be easily accessible in terms of what's posted on the website. So I encourage people to follow documents that are on the website as well. I would anticipate we're going to focus on the areas, at least in terms of our committee time, on the areas where the House has provisions that they're bringing to conference that we don't have, that we will have provisions that the House doesn't have, and then on areas where we have provisions but they're not quite same or similar, and we have to sort out some policy differences or language and, of course, the money differences. So what I'd like to do now is to invite the House members to present the policy provisions that the Senate hasn't seen or heard yet, so that we can learn about them, and understand them in some detail, and understand why you are an advocate for those policy provisions. So I think maybe, I don't know, should I follow the list, Chair Moller, that you gave to me? Well, Chair Moller, you're first. So why don't you just go ahead and introduce the bills that you're identifying, and give us some information on them. If you have any testifiers or information you'd like to have handed out, of course, we can make that happen as well. Chair Moller.
Yeah, thank you, Mr. Chair. And my understanding was this is just going to be more of an informal discussion about these proposals, so we don't necessarily have testifiers here, although I will say some of the letters that are being put in the packets are related to some of the things that we're going to be discussing today. And those will be posted online for folks who are wondering what we're looking at or what we're talking about. Those will be available to the public as well. So just wanted to make that clear. The first provision, or the first bill that I was asked to speak about, was House File 2510. And this has to do with the license requirements related to the Board of Private Detectives and Private Agent Services. We funded in our provision 4 FTEs and changed some of the language, expanded the scope a bit of this board beyond what the governor's proposal was 2 FTEs. And the reason we did this was twofold. We heard, first of all, from the board itself that there are, and I hope I have these numbers right, but there are over 384 license holders in their database, but there are actually 510 according to deed. And so what they were finding was that there was a lot of companies who are hiring, quote unquote, these private detectives or private agents who aren't actually licensed. Quite a number of people, kind of an alarming rate that there are folks that are out there who are unlicensed, untrained, undertrained, could be carrying firearms. And we think that part of the increase with this sort of happening is because there are a lot of private businesses that are relying on security now with law enforcement shortages. And so we want to make sure that people who are serving in these roles are properly trained and properly licensed. And so our bill expands the ability of the board to look into that activity. Right now, they don't have the authority to examine that unlicensed activity. And so our bill allows for them to do that and then gives them the staff they would need to do that. And the other thing I'll say is, beyond hearing from them about that issue, we also heard from community members who were having concerns about some of the behavior of some of the unlicensed folks that are serving, in these roles within their communities. So that is my summary of that bill. I don't know if you want me to go on and talk about the other ones, or pause and.
Well, let's pause and see if any members of the Senate side in particular have any questions that would like fleshed out. I guess one question I have is how much of an increase over current funding levels or complement is represented in the House position?
Thank you, Mr. Chair. And I might turn to Mr. Walls here for nonpartisan fiscal staff. I have a spreadsheet handy, but maybe he can find it faster.
Madam Chair, I'm sorry, we were discussing a fiscal note here. What provision were you talking about?
So we are talking about the Private Detective Board.
Okay.
And I believe the question was what is over the current budget for that board.
Madam Chair, we, I believe, gave them 2 additional positions over what they were requesting. And I'm not sure that everyone has the spreadsheets that we're going to hand out for committee. So I believe I'm on a different a different sheet than you are. The House has 1.446 million for the biennium for the Private Detectives Board, and the Senate has 887,000, and primarily that is due to the additional positions that the House funds.
Chair Moller.
Yeah, thank you, Mr. Chair. I would just say, too, I have some notes here from when we had the presentation, and I believe that they currently have 3 full-time employees, an executive director, and 2 others, and then 1 part-time staff. And I know they had said they had seen quite an increase in those applications, and they were having difficulty keeping up with the current workload that they have.
Chair Moller, are you anticipating this as a ongoing funding, reflecting an ongoing increase in applications?
That's right, Mr. Chair, and part of it is with our bill, we were expanding the scope of their work, like I mentioned, with respect to the unlicensed activity.
Any members of the Senate have any questions to follow up on this? Chair Moller, your next bill, please.
All right, thank you. The next bill is House File 424. It was a Representative Bonner bill, and it expands the list of qualified domestic violence-related offenses. I believe this bill has been around in various forms over the last couple of sessions. But basically, if an offender commits certain crimes within 10 years of being convicted of a qualified domestic violence-related offense, we call that a QDVRO, that prior conviction can be used to enhance the penalty for the current or the more recent crime. That's already in statute. But what they were finding, and I believe that this happened in Maple Grove, the area that Representative Bonner represents, was that there were some types of crimes that really were domestic in nature but weren't covered as a qualified prior domestic violence, and particularly manslaughter. I think they had a situation where there was a manslaughter. They weren't unable to use that to enhance then another domestic violence offense that happened later. And so we took a look at that statute and added in a couple of those crimes that really we felt were missing that should be considered as enhancement if there's another domestic violence offense that occurs later.
Chair Moller, does the manslaughter provision, is it connected in any way to domestic offense, or is it any manslaughter?
We did do some narrowing with an amendment to really kind of try to hone in on those particular crimes that we had listed in this bill. And I don't remember exactly what provision. I wonder if our nonpartisan staff can, I think it was Mr. Diebel perhaps, or Mr. Johnson, it looks like, that worked on that.
Mr. Johnson.
Mr. Chair, members, the provisions that are added include all of the third-degree murder except for the provisions related to delivering a controlled substance. The additions for first-degree manslaughter are clauses 1, 2, and 5. Those exclude the provisions that are related to coercion by another person or causing a death, again, by selling controlled substances. The additions for second-degree manslaughter include only clauses 1 and 5. Clause 1 is manslaughter through culpable negligence, and 5 is when someone attempts to commit a violation of neglect or endangerment of a child. It excludes several other provisions, including shooting someone with a firearm, believing the person's an animal, setting a spring gun, and 1 or 2 other provisions.
So I guess I'll just tell you my predisposition on that entire statute, actually. It's been a long-standing one, is that even though it's titled Qualified Domestic Violence-Related Offenses, quite a lot of the offenses that are listed there have nothing at all to do with domestic violence directly. While they are indicators of violent tendencies, they're unrelated to domestic violence specifically, and so I've had heartburn over the years about whether they are appropriate to use to enhance domestic violence-related offenses. So I'm a little bit hesitant about expanding the list, and especially expanding it with more non-domestic related offenses. But clearly a conversation that we should have. Chair Moller.
Yeah, thank you, Mr. Chair. And I'll say too, when the bill first came to us, it did have, I believe it had all of first-degree manslaughter, all of second-degree manslaughter, all of third-degree murder. And so I worked with my Republican colleagues on crafting the language to really focus in on, again, eliminating the third-degree murder related to controlled substances and really focus on those provisions that that could be related to violent acts that would be qualifiers for domestic violence, perhaps. The same thing with manslaughter, trying to exclude some of those provisions, like accidentally shooting somebody and thinking it's an animal. We tried to, I understand your concerns, but just, that we did work to try to narrowly craft the provisions that we are adding into this statute.
And of course, any prior convictions would still show up in the criminal history score when they're evaluating sentencing guidelines outcomes as well. Any questions from members or comments from members of the Senate? Or anyone else in the House wanted to add anything I should ask to? And I would assume there was a fiscal notice affiliated with that as well. Presumably it would have an impact on vet space.
That's right, Mr. Chair, and if Mr. Walls maybe could give that amount.
The QDVRO change was House File 424.
Mr. Walls.
Mr. Chair, the bed impact for that was 66,000 in this biennium and 171,000 in tails.
Any other questions or discussion?
Yeah, Mr. Chairman.
Senator Pappas.
Yeah, I'm trying to look up the bill on my phone, and I'm not sure if the version I'm looking at is as introduced or as passed in the House, included in the House, but it does seem like a number of these would be very much related to domestic violence, malicious punishment of child, terroristic threats, violation of domestic abuse, no contact order. So I think that we should really give this very serious consideration.
Any other? Representative Curran.
Thank you, Chair. And I just thank you, Senator Pappas, for that. And just to kind of go off of that, I think it might be fair to say that some crimes don't directly, they might not directly have anything to do with domestic violence itself. But what I would say is what we don't want to do is create a separation from a person and different types of crimes that they may be committing. And so I think there really is a relevant connection with the crimes that are listed here. That are indicators of somebody who may be violent or take advantage of others, and that's behavior that we see in domestic violence as well. I also agree that this is something that we need to take a serious look at because, we're having to look at the person and what that person's record is, and I think that it's warranted to consider the crimes that are listed in this provision.
Chair Becker Finn.
Thank you, Chair Latz. And I think, the concept of the QDVROs is really important, and I don't think any of us take it lightly to add offenses to this. I know this has been a thing that's been under discussion in all of the years that I have been here. I can also tell you that when I was focusing on prosecuting domestic violence crimes, part of the reason is that, these aren't necessarily connected. We don't want to make it impossible for, so this is what I would do when I would come in to work and look to see if something was enhanceable. You'd go through and you'd pull up the convictions. Well, a conviction for manslaughter, second-degree manslaughter, whether the victim was a relative of that person or not, it's the same code in the system. So I think part of the thing we have to keep in mind is that the whole premise of the QDVRO system is also, the way that our statutes are laid out, and it's not like there's a separate charge for a domestic burglary versus a regular burglary. And I think to what Representative Curran pointed out, it is really important. These things are precursors. They are, these are crimes of violence. And I think especially in the broader context as we talk about domestic violence and its connection to shootings, its connection to violence against other kinds of, other people who aren't related. I think it's, I don't want us to walk back or I want us to make sure we're careful and not sort of undermining the premise that we use with the QDVRO system. And I think a lot of us take it really seriously. And if you can't get to, it's convictions. It's not just, you'd have to be convicted of these things before those things are allowed to enhance those charges. So I just, I think it's really important that we move this forward, and it's, certainly we can further discuss it, but I just, I don't want to undermine overall what QDVROs, the role that they play in our system in holding domestic abusers accountable, because often that is the tool to hold folks accountable and get it to that felony level where we've got our county attorneys and our more experienced prosecutors working on those things. So just wanted to put that out there as someone who literally spent all morning pulling up cases and checking to see which things might apply in which scenario. So thank you, Mr. Chair.
So my concern, of course, is that if we're talking about enhancing, I take this as seriously as anyone does, and but we're talking about enhancing domestic violence charges. And it just seems to me that a connection between a prior domestic and a new domestic is very easy to draw. But a prior violent crime, which will be factored in already in the sentencing practices, may not be appropriate for formally enhancing a new domestic offense. And so that's the philosophical issue that I'm struggling with. I have, as I say, for many years. I'm not suggesting that we go back and change the entire list of QDVROs, but I'm skeptical about expanding that list into additional crimes that themselves had nothing specific to do with domestic-related conduct. So, anyway, I look forward to the discussion. Any other thoughts or comments related to this? Not seeing any. All right, Chair Moller, your next bill, please.
Thank you, Mr. Chair. The next bill that I was going to talk about, excuse me, was House File 2041. It is a Representative Gomez bill related to syringe service providers for harm reduction. And I think before I get into the specifics of that, I'll just lay the groundwork for what we worked on in the House when it comes to substance use, particularly when we're looking at the fentanyl crisis. We spent a lot of time, again, working with our colleagues across the aisle over here to really try to focus on the fentanyl dealers. And I know there is not necessarily a fine line, especially when you get into some of those lower amounts. And I believe our bills match up with respect to the first through third degree changes that we're making to the controlled substance crimes related to fentanyl. But one of the things that was really important to us was to look at this holistically and think about the public health crisis that is our substance use crisis going on. We know that the war on drugs has failed, and we really wanted to, again, look at this from a comprehensive standpoint. And we recognize that a lot of the bills and work that's being done in this area isn't necessarily something that comes through the Public Safety Committee, although it certainly impacts public safety. And so along with the changes we made to the penalties for fentanyl, we also wanted to make sure that law enforcement were carrying opiate antagonists, so that was included in our bill. We had an amendment put on a bill in the Health Committee to make sure that all EMTs have opiate antagonists. I know that the Education Committee and that bill considers the availability of those opiate antagonists in schools. So we want to just make sure that those resources are available everywhere. And we also want to make sure that we're not criminalizing people who have substance use disorder. And that's where this particular bill comes into play. There are syringe service providers in the community, and the data surrounding the work they do is, I think, really important to focus on. We know that people who have access to these syringe service providers are 5 times more likely to enter treatment and nearly 3 times more likely to stop reduce or stop injecting. And there's also been a 42 to 66% reduction in the transmission of HIV. And so what our bill does is recognizes that the important work that these syringe service providers does, make sure that they are included in the list of entities who can dispense and dispose of the hypodermic syringes or needles, also allowing for participants to be able to exchange these needles, and then decriminalizing by repealing the possession of drug paraphernalia, because again, we don't want to punish people who have substance use disorder. And then I'll just say the final piece for us in looking at this was a Representative Pinto bill to do a study on how we're handling controlled substance offenses in the state and how we can look at doing something differently, more creatively, because again, we know the war on drugs has failed. So we feel like the changes we made to the fentanyl language is really a Band-Aid for a larger fix that we know is needed. That's one that's rooted in the public health crisis that is our crisis surrounding drug cases.
Any questions, Senator Umover Baden?
Thank you, Mr. Chair, and thank you, Chair Moller, for just a really great description of the bill. I carried this on the Senate side, so I was very pleased to see it in the House bill. And I think you did a great job of explaining that, you know, addressing this crisis is not just the enhanced penalties, but the harm reduction that we see in this bill and the availability of Narcan in both our committee and some of the other committee bills that we see. I just wanted to draw everyone's attention to the letter that we received from the Minnesota Harm Reduction Collaborative. They do a great job of explaining what is in this bill and some folks that are in support. So, of course, the collaborative themselves, Minneapolis Students for Sensible Drug Policy, the Addiction Medicine Consult Team at the University of Minnesota Medical Center, and then the last letter here is from some retired pediatrics. So there's a lot of great information in there, and I'm very much in support of this. It's a top priority for me. Thank you.
Anyone else wish to comment? Representative Frazier.
Thank you, Chair Latz, and thank you, Chair Moller, for the description of the bill. I think it's very important that whenever we're moving forward in any type of policy, that we use the knowledge that we have. When we know better, we do better. And we know that the drug policies of the past, I grew up in the 80s in Chicago, and this was a time when, 80s and 90s, and this was a time when in the 80s, the use of crack was really taking hold in particular communities, particularly poor Black and brown communities. And the drug policy then, the enforcement policy, was really one that was very punitive. And in many cases, it was individuals that were addicts, not sellers of the drug, addicts, that had the brunt of that punitive policy. And it was disruptive to communities, it was disruptive to families. There are still reverberations of the outcomes of those policies, yet and still today. And it should have been a public health policy that was used during that time and applied. And I'm really glad that we're now taking that knowledge that we have. We do know better, and we are doing better with these policies. Thank you.
All right, Chair Moller.
Thank you, Mr. Chair. I have one more on my list to discuss, and that is House File 1182. This is a Representative Novotny bill, and we did pass this actually off the House floor, I believe, with unanimous support, if I'm not mistaken. Seeing some head nods over here. And this bill is amending the use of deadly force standards. So when the legislature changed this law after George Floyd was murdered, one of the provisions of the law said that the officer's use of deadly force must be articulated with specificity by the law enforcement officer after an event. And we had a court declare that piece of it unconstitutional because it was basically a violation of the right against self-incrimination. And so that particular language by the law enforcement officer was essentially struck by the court and said that the justification for an officer's use of deadly force may be based on an objectively reasonable standard for officers generally, as opposed to the assessment of that particular officer in question. Because again, that was a violation of the right against self-incrimination. And so we took that court decision, Representative Novotny did in his bill, took that court decision and just struck that language by the law enforcement officer from the statute so that our law now will match up with what that decision was. And we really think this is an example of areas in Minnesota statute where we need to modernize our statutes and recognize certain court decisions, and that's what we did with this bill.
Any questions or discussion right now from members of the Senate? Or additions from members of the House? All right, before we move on, I'm told that Commissioner Jacobson is here. Commissioner, would you just come forward and introduce yourself briefly?
Good morning, Chair Latz, Chair Moller. Thank you. I am Bob Jacobson. I'm the Commissioner of Public Safety, sworn in on January 2nd. It's been an honor to serve the last 4 months. It'll be my 4-month anniversary tomorrow as the Commissioner of Public Safety. Just want to thank you for all of your hard work and your diligence as you've gone through this legislative session. My understanding is that this has been one of your most busy legislative sessions, at least in recent history. And again, my apologies on my tardiness this morning, but glad to be here and again, look forward to working with all of you. Thank you.
I assure you, your tardiness will not affect your budget.
Oh.
Thank you, Commissioner.
Thank you. Can you put that in writing, sir?
You're asking a lawyer to do that. Smart move. I'm on the record, clearly. All right, Chair Becker-Finn.
Yeah, I've got a couple different ones here. So the first one is the bill establishing a statewide office for appellate counsel. Senator Westland carried this on the Senate side. So I actually have a lot of new members on this conference committee as to where we were 2 years ago. So 2 years ago, we passed a law that gave parents a right to counsel when they were faced with potentially losing custody of their children in child protection matters. So that's already a right, and so this is sort of the next step in that process, and establishes a statewide office of appellate counsel and training, so that eligible parents would be able to have counsel in appeals at the appellate level as well. So it essentially sets up a statewide office, directs them what they need to do, so that what we have right now is a system where it's a right, but parents aren't necessarily able to access that right because we don't have the systems and the training in place yet. So even if they have attorneys at the first level, when they get to the appellate level, there are kind of strict timelines, and a lot of parents are essentially losing their chance to make their case to keep their kids. These are permanent decisions that are made about children. So the idea here is that we're going to set up a high-quality statewide office that would help parents across the state.
Chair Becker-Finn, are there any limitations on eligibility for the services of the appellate counsel?
Yes, Chair Latz. So it'd be the same eligibility as the same standards we use for public defenders. So if people are able to afford their attorney, that's on them. But it's the idea is that low-income parents are not disproportionately losing their parental rights.
And where would this office be set up? Would it be part of the judicial branch, or would it be an independent agency like the public defenders' offices?
Good question. So it'd be similar to public defenders. There'd be a board, and it would be appointed by both the governor and the Supreme Court.
Any questions or comments from members of the conference committee? Senator Weston.
I would just say, again, as the author in the Senate, this is a great bill, and we know that one of the great challenges in our legal system is access to legal services. It happens so much on the trial court level and even more so on the appellate level, where it's so important for someone to have representation. It's certainly one thing for a pro se person to come into family court and represent themselves, but doing so on an appellate level is really nearly impossible. So I appreciate the partnership here, and this is a really, really important access to legal services provision.
Chair Becker-Finn.
All right, so moving on to the next one, I think this is great, even just like picking up these couple little bills, you kind of get the full breadth of the type of work we do in these committees. So next one is updating a statutory definition of park zone. So as hopefully we're aware that one of the aggravating factors with controlled substances crimes is, whether it happens near a park zone. The current definition of a park zone is limited to areas designated as a public park by federal, state, local, park district board, and park and rec boards, and does not include tribal governments. This was actually a request from one of our tribes that if it's a park that's designated by a federally recognized Indian tribe, that it be included in that definition of park zone. It was not controversial at all in committee.
Any committee questions or comments? Chair Becker-Finn.
All right, moving right along. So this next one is funding for First Witness Child Advocacy Center. So First Witness Child Advocacy Center is a Duluth-based nonprofit that does work around children and who are victims of child abuse and their families. So kind of a multidisciplinary approach where they're setting up a way to do forensic interviews in a way that is not exacerbating the harm and trauma that's already occurred to children. First Witness, they serve the whole kind of northeast region of the state. So, really a focus on our rural communities and making sure they have access to these services. It's Representative Kozlowski bill. Recognize that, this is the type of thing that's not necessarily always funded in a judiciary omnibus, but I think it's really important around the work we do around preventing crime and child abuse and holding people accountable. So included it in our bill.
Senator Pappas.
Thank you, Mr. Chairman, and Representative Becker-Finn. Is this operating dollars for the program? Because they have a request in front of the Capital Investment Committee.
Chair Becker-Finn.
Mr. Chair, no, this is so that they can make the improvements to their building. I know that they have made that request to capital investment as well, but you are well aware, there's no guarantee that there will be a bonding bill or that any given project will be included, and we wanted to make sure this got done as soon as possible. They do have more than matched the dollars in their own funding in their community.
Mr. Chairman, how much do you have in your bill for them?
Mr. Chair, it's $1.5 million.
Thank you.
So I guess that kind of dovetails on mine. I wasn't sure if this is a new organization or if this is an organization that's different than any other organizations that are out there. Chair Becker-Finn.
Thank you. So no, it's an existing organization. They served over 210 alleged victims of child abuse. They provide trainings throughout the northeast region of the state. It's a rural area, a lot of tribal communities, a lot of overlap with the folks that they're serving. So it's Duluth and the whole northeast region of the state. They are established, but their current facility is not conducive to doing the work in a way that they can serve the people who need to be served and do it in a way that's not causing more harm to these kids.
Chair Becker-Finn, do you know if, I'm familiar with some of the organizations in the metro area anyway that do similar work. Do you know if the legislature has ever funded their building requests or anything like that in the past?
Chair Latz, whenever somebody asks a question if somebody has ever done anything, I don't know, but not to my knowledge, but that doesn't mean it's never happened.
So we'd be setting something of a precedent door to this particular kind of an organization through this budget. It might be in a more appropriate capital request where there are different criteria that are necessarily applied. I guess I'd raise the question whether or not we reopen the door to other similar organizations coming to the Judiciary Committee in the future, asking for funding of a similar nature.
Yeah,
What's your thought on that?
Yeah, I think that's a fair question, and I think one thing alone is not necessarily opening the door or setting you up. I think the question is what we would do after that. And maybe a special circumstance where we've decided to do that this year and this time for this purpose, and I don't think you can make the argument either way. This was an outlier. We did it one time. We're not necessarily going to do it ever again. But in this case, I made the call that this was really important, and I wanted to make sure it got done and not sort of stuck in the gamesmanship and whatever ends up happening with a bonding bill with, however, the chair could say, but I don't even know what the requests are. Not every bonding project is going to get funded. And this is one that has to do with child abuse and protecting kids. And I had room, and so I decided to include it. It's a one-time as opposed to ongoing funding, and I think it's important. But I think, my argument would be, there can be special circumstances where because it's never done before, doesn't mean we can't do it this one time.
Any other questions or comments? Representative Kern.
Thank you, Chair. And I would just add on to that, there's, like Chair Becker-Finn said, there's a lot of different ways that you can look at this. And if we're talking about doing something different as far as setting precedent, I would argue that we can also set a precedent by seeing a large gap in needs that we have the resources to fund right now. And so that's something that Minnesota can show that it's not necessarily establishing a new precedent in how we fund or what we fund in the future, but perhaps a precedent in the needs that we see and our willingness to take some of that surplus that we have and apply it to those great needs that we have, even if it's one time. So I think there are different ways that we can look at this and setting ourselves up in the future. But I would say I do think it's appropriate to have this in the judiciary budget, and I say that because we're looking at providing legal resources for families, specifically for children who are victims of abuse. And in order for us to best prosecute those cases, we need to make sure that those kids and their families have the right tools and the right people available so that we can get the information from these kids in a way that they're able to share it. We need experts in the room who are able to do this and hopefully only expose the kids, minimal times to having to share their story so that we can then effectively prosecute that case. And then that's twofold, right? If we're able to prosecute and get a conviction from that case, through that process, we're also potentially, we are helping that child through the trauma that they've already gone through and potentially preventing them from becoming, engaged in future harm of another too, and making sure that they have the appropriate resources not to get caught in a cycle of crime. So I just wanted to point all that out, that I really do think this is a great justified use of one-time money to put toward our judiciary system. Benefits kids in our greater Minnesota area. We already know we do that here in the cities. So just want to make sure we're taking care of folks in greater Minnesota, and I think this is a good way to do that.
Any other discussion right now? Questions or comments? Chair Becker-Finn?
All right, moving on to the next one, different direction. So House File 321 is having to do a data provision, Chapter 13. It's our first one of the day. Student directory information, and I'll just be honest, I had Senator Lucero had said he'd be willing to carry this, and I lost the jackets, and with the backup in the revisor's office, they were not able to get them new jackets to me. So that's why you don't have a Senate author. It's just a function of I'm a human and I lost the papers and we couldn't get new papers. So we'll just lay that out to begin with. So essentially this would protect students' personal contact information from being public information. Right now, the default in our state law under Chapter 13 is that a student's name, home address, phone number, email, and for student athletes, even their height and weight is considered public information unless a school has like affirmatively chosen to set up some other kind of system. That honestly, in this day and age with the internet and all of the other things that are out there putting our kids at risk, is trying to close that loophole and make sure that that information about children is not public information. Initially came to my attention when I was first elected, and there were threats against me and my children, and I reached out to the school, and they were like, "Oh, okay, well, we'll designate yours as not shared." And I was like, "Wait, what is that? What?" And so then they had shared with me that, you know, the default is that information like that is public, and in theory, anyone could call up a school about anyone in this room and ask for your kid's name and home information. And that is terrifying to me. And I think we are talking about minors, we are talking about children, and keeping them safe should be our top priority. So this, yes, it would make it harder for people to send out grad letters, but I think protecting our kids should be our top priority. In the process of talking about this bill over the last couple of years, I also learned that there are also for-profit colleges who are using that public information to target student athletes and other high school students with misleading information. Things like a for-profit school, I think it was in Kansas, reached out to a student athlete as if they were recruiting them to come play on a sports team. And then once this kid got really excited that someone was looking at them to come play for their team, turns out, oh, it's $40,000 a year and there's no scholarship. But they're sort of using that publicly available information and contact information to reach out to these families. So this has been vetted through the Data Practices Commission. We had agreement on it last year, and we just didn't have a bill. So I'm hoping we can finally get this one across the finish line again. We referred it out of our committee. There was only one no vote, and have been working across the aisle on this for a couple of years. As you can tell, I'm very excited about this Chapter 13 change.
Oh, we wish that everyone were as excited about Chapter 13.
We've got a couple over
Chair
here,
Becker.
Mr. Chair.
But no more graduation letters?
Mr. Chair, you could
tragedy.
You could still do the graduation letters. I know one of my high schools, if I give them the letters, they'll get them out to the graduates, but I don't need to know their home addresses.
Any other thoughts, discussion from the conference committee? All right, Chair Becker Finn.
All right, last but not least, another Chapter 13. So I've been the author for many years on provisions around chronic wasting disease. And one of the provisions that we had this year, we kind of did it, in past years we've done multiple standalone bills. This year we kind of did one big bill. So there's just one provision, Section 1 in the bill. Right now, the location of these deer farms is non-public information, which means if you are buying a cabin, if you hear that there's an outbreak in your area, it makes it basically impossible to figure out where these places are located. So it's just a small change that would make the location just of Cervidae farms would be public data. So, I think initially when this protection was put into statute was sort of in the years of sort of misplaced fear that there were, roving groups of PETA members out to get farming operations. This is just to make sure, if you're going to buy that cabin, if you're going to go hunting, that you're aware. I know even when we've had outbreaks, I can't even when there's a positive, we don't even know where it is. We're just told the county that it's located. So this would just make sure that those businesses, that we'd be able to know where they're located in the state.
Any questions or comments on that bill? Vice Chair Feist.
Thank you, and I'm going to head up to the chair up there because I have a couple of people with me who are going to speak briefly, if that's okay.
Of course.
You want to sit? Cool, thanks. Okay. Cool. So So my bill would create the Office of Restorative Practices to provide a statewide structure to build capacity to use restorative practices and administer grants, and provide technical assistance and oversight to restorative practices statewide. Restorative practices identify the underlying causes of behavior, empower children, families, and communities to take an active role in the prevention and early intervention of behaviors that lead to involvement in juvenile delinquency, child protection, and out-of-home placement. These practices are more effective in reducing recidivism than traditional sentencing and are dramatically more successful in providing healing and closure for those harmed by youth violence. They are also effective in addressing the stark racial disparities in the treatment of BIPOC youth under the current systems. In crafting this bill, I have had in-depth meetings to solicit input from prosecutors, judges, and defense attorneys, child welfare professionals, youth justice advocates, restorative justice practitioners, professors, educators and school administrators, police officers and probation officers, religious leaders, colleagues on both sides of the aisle, impacted community members, organizations representing individuals who have been harmed by violence, and retired Colorado State Senator Pete Lee, and Deb Witzel. She's the first state coordinator for restorative justice in Colorado, and they really did a lot of innovative work and passed a lot of legislation around restorative practices, and we're trying to build on that momentum. My presenters today will speak very briefly, I promise. Amanda Sealing is here to share Yellow Medicine County's remarkable success over the last 20 years in the program that she helped create. Reverend Kendall Hughes behind me experienced harm, experienced violence, and addressed it through restorative practices. And Brenda Burnside is also here to answer any questions that people might have. She is a restorative practitioner, restorative justice practitioner, who collaborates with Ramsey County Attorney's Office, and she's here in her personal capacity. And we do have some materials also that are awesome and that you should check out. And with that, I'll let my testifiers speak briefly.
So Representative Feist, if there are materials you'd like distributed to the committee, we can go ahead and do that now or at some other point.
You already have them.
Oh, they've already been handed out?
Yeah.
Okay, great. And I understand some of your testifiers have come from some distance, so we're not going to try to enforce a 2-minute limit or anything like that. Please go ahead and enrich us with your testimony. Go ahead, identify yourself and spell your name if you would, so we know.
My name is Amanda Sealing. Sealing is spelled S as in Sam, I-E-L-I-N-G. And I did, actually, I'm a professor currently at Southwest Minnesota State University out in Marshall, so I came from about 3 hours away this morning. And I actually have to thank my students because the only reason I can be here is because they agreed to change a final. I was scheduled for finals today, and they agreed to change it until tomorrow. So I appreciate it. I know it was a big sacrifice.
An extra day to study.
But I am speaking in favor of including the Office of Restorative Practices in the accompanying grants in the Public Safety and Judiciary budget bill. I am currently a professor. Prior to my tenure starting at SMSU, I was actually a prosecutor for over 15 years in Yellow Medicine County. During that time, I joked with my friends in the Metro who were county attorneys that they were members of a juvenile division, whereas I was the juvenile division in Yellow Medicine. And so I was responsible for charging decisions and dispositional decisions. And in 2002, placement costs in Yellow Medicine County were skyrocketing. Now, I'm not saying they're the same as they were in the Metro, but I am saying that we were spending hundreds of thousands of dollars every year placing children, and only to have them reoffend when they came home. So in response to that problem, a group of us got together, led in training by Mille Lacs Band of Ojibwe and Dakota teachers, and we started referring youth to circles. As a prosecutor, I have to be honest, I was super skeptical. The idea of handing over my cases to the community, I was really worried that it was going to be some kind of situation where people would sit in a circle and hold hands and sing Kumbaya. But instead, circles who were made up of volunteers, youth, and youth supports spent hours every other week for months, even years. And what they did is create relationships that are meaningful and lasting. And through those relationships, youth are held accountable for their behaviors in ways that the system simply doesn't have the resources or the capacity to do. We in Yellow Medicine County have found out firsthand what researchers across the country have found out, which is kids who feel their community actually is invested in them are less likely to commit crime in their community. Relationships are the key to changing behaviors. When young people are excluded from their communities for mistakes that they make, this disconnects them from their community, and that's not what they need. They need connection. Our communities are positioned in a very unique way to provide that connection. And I have to be honest, as a prosecutor, I understand that the justice system bears witness to some of the horrific consequences that come from the mistakes that people make. And it's hard to imagine inviting the community into that. We want to protect them from that. But what restorative justice really does is it empowers the community. It empowers them to be involved, and it empowers them to make change, step forward, and hold people accountable in ways that result in real and significant change. So I urge that you include this in the bill. I look forward to any questions that you have.
Thank you.
Okay.
Any questions right now? So stick around for the discussion. Appreciate you coming here and testifying. Sir, go ahead and
Yes. I'm
introduce
Kendall
yourself.
Hughes, and I am from Rochester, and I have several colleagues that have come with me also here that help me with restorative justice there. Ernest Schaefer had spent 16 years becoming increasingly violent behind bars when he snuck up behind me and stabbed me 12 times in the head and the neck, just missing my carotid artery. As traumatic as that event was, what the federal prison system did to Ernest and what the assistant U.S. attorney and the federal justice system did to me after that was nearly as bad. Ernest was sent to the Supermax, where he spent 8 years in solitary confinement, was released from that to the street, where, not surprisingly, within a month, he assaulted 2 women and now is spending the rest of his life in prison. I was never given the chance to ask him why he did what he did. I was never a chance to tell him the harm that he had caused to me and to my family, to my co-workers, and to the community that were affected by that crime. Never able to ask for any kind of reparations. Was never given a chance to see him do anything to better his life so that he would not become increasingly violent. Instead, I was told that I would be given a victim impact statement that really would not affect the outcome. It took 2 years to go to the sentencing for him. During that time, I rehearsed, I practiced, I memorized my victim impact statement. My family had moved by that time, had to travel back 800 miles for his day of sentencing. I sat in court all day long, and the judge forgot about me. The thing that did help me begin to move out of the paranoia and the depression that followed that traumatic event, the thing that began to lift me into something healing, was restorative justice. After that judge forgot about me, I knew there had to be a better way to help victims of crime. And so I got involved in restorative justice, and for the last 20 years now, I've directed programs that have helped hundreds of people get answers to their questions, to be able to tell the person that harmed them the impact it had on them and their family and on others, to get ask for the reparations and get the reparations and restitution that they need, and to see that person get the help they need so they don't go on and become more violent. I believe that Minnesotans deserve an option that's more than just the one current option that victims of crime have that doesn't give them much of a choice and that is very costly. So I ask you, Madam and Mr. Chair and members of this committee, would you give Minnesotans an option that gives them a meaningful voice that costs 1/8 of what the current system costs? Would you include this in this legislation? Thank you.
Thank you, Mr. Hughes.
Any questions?
Any questions right now? Not seeing any. Thank you. Please stick around. Representative Feist, you had another testifier?
If we have time, Ms. Burnside did come. She was available to answer any questions, but she does run a very successful, or participates in a very successful program with the Ramsey County Attorney's Office. Would you like to say just a few words?
Sure, she's welcome to come forward.
Good morning. Thank you for having me.
Today, I just want to talk a little bit about
Please
restorative
introduce
justice.
yourself for the record. So
Oh,
we
I'm
have
sorry. Brenda Burnside. And what else do you need?
Your affiliation.
I'm a community member. I also run a business called Let's Circle Up, which I founded and I'm the CEO of. I just want to talk a little bit about what restorative justice is and what it does, because a lot of people really don't understand what it is. I will say that it is a process that involves accountability, but meaningful accountability, and that's what we kind of avoid in the juvenile system right now. One of the things that we don't really talk about is what this gentleman just talked about, is that you never really have to see the people you harm. So it's not an abstract thing. It's walking past people that you hurt every day. It's about looking at the harm that you've done in your communities. It's about facing the people who have supported and encouraged you and having to say to them, I messed up. That's the accountability that we're looking for. But in the current penal system, you never have to see the people you hurt. It pulls you away from it so you don't see anything. So that meaningful accountability is missing. And even in our, when we communicate, sometimes we communicate just to talk, not to engage or connect. And that's what our communities are missing. Right? So many of the children who have done harm, I worked in the school system for 13 years, and I worked with special ed kids at the level 3 federal setting. And in that, the kids say, I'd rather be suspended. I'm not going to apologize. They don't want to look at the person. They don't want to work with the person that they've been fighting with. And if you have children, when they've done wrong, they don't want to see you. They'll go in the back door. Right? I have 2 children of my own, and they avoid that accountability. So when people think that you're letting people off, you're doing anything but that. They want to avoid that interaction. And accountability cannot happen in isolation. So when we isolate people and put them in cells, they're not held accountable. They never have to see you again. They never have to look at what they've done. And usually it's not even brought up. This gentleman sat in court and was waiting for his time to actually even say to this person, you hurt me. You did this, you did that. I was impacted this way, I was impacted that way. So that meaningful accountability didn't happen. And this whole process actually came into the United States in the 1970s. And it was to address the system that was not working for us. However, we only implemented it in certain spots for certain cases. It was never across the system completely, so it never really took root. Right? So we never had the mindset change. We never had the shift in perspective that should have happened for it to be successful. So even now, we're only doing it piecemeal. We're not doing it across the board. So anyway, restorative justice is something I could talk about forever, and I don't want to do that in this space. So I thank you very much, and I'm open for any questions that you may have. Thank you.
Thank you, Ms. Burnside. Are any questions or comments from any members of the committee right now? Senator Pappas.
Thank you, Mr. Chairman. I think this is a really good example of the kind of transformative work that we would like to do, I think, as a conference committee, to really take a whole new look and a whole new perspective on criminal justice in our society. And I know that work was going on in the 70s and 80s, and then we kind of lost sight of it. And here we are 50 years later, almost 50 years later, reviewing what we should have been doing back then. So thank you so much, Representative Feist, for bringing this forward.
Senator Seeberger.
I want to thank Representative Feist for this work. As I was going through the materials, I saw a letter of support here from Northeast Metro 916. And my younger son, who I referred to earlier, is my little guy. He's not little. He's 6'3" and 320 pounds. He could be a linebacker, but he's my little boy. He has autism and some mental health concerns, and he was a student at Northeast Metro 916 for many years in a federal setting 4. And there's a story here on page 2 of a student who physically assaulted an SRO. As I was reading it, I thought it was the story of my son, until I got to the part where it said that all parties agreed to or participated in a restorative circle. And I wish that it had been offered to my family. Instead, my son, as a 5th grader, when he was 11 years old, was arrested, charged with felony assault, brought to juvenile detention, Ramsey County Juvenile Detention, and was sucked into the system for a year and a half until we could finally get him free. And part of his probation, part of him being released from detention, was a condition that he engaged in no same or similars. And as a kid with autism and behavioral disruptions, his whole life was same or similars. And we had to discontinue behavioral therapy. We'd had a setback of a year and a half in therapy for my boy because of a reactionary SRO and a prosecutor who would not understand his disability. It was the worst time in our entire lives. And I'm feeling it now, and it was awful. I would not wish this on anyone, on any parent, on any child, on any school staff. So thank you, Representative Feist, for bringing this forward. And I will enthusiastically support restorative justice as a means to restore these folks to their community, to the right path, to treat them with dignity, to understand what's at stake here, and not simply to punish. So thank you.
Representative Frazier.
Thank you, Chair Latz and Senator Seeberger. Thank you for sharing that story. You know, I think Representative Feist, thank you for bringing this bill, and I think that story is an example of what we need to address. And systemically, we have not been able to do that. I mean, there are too many stories just like that we have, that if we were doing things differently, we wouldn't have those stories, right? And again, this goes back to kind of what I said earlier. When we know better, we'll do better. And the data and the studies and the outcomes have shown us that we know better now, we can do better. I did have a quick question, and maybe for the first testifier, if you want to come back up. And Senator Seeberger shared her personal story and how this could have helped her son and their family in that situation. And I was wondering if you could give some examples of how, when we use this restorative process, it helps with cutting back on recidivism, and it helps on just public safety overall. If you can just give some concrete examples.
Ms. Sealy.
Thank you, Chair. We've been doing restorative practices in Yellow Medicine County for over 20 years at this point, and there are countless stories, and they're not really mine to share. I was the prosecutor who referred the kids. I will tell you that when I started prosecuting, we were at over $600,000 of out-of-home placement costs, and those are all property tax dollars. And I understand that $600,000 is a drop in the bucket to a lot of counties, but we've 10,000 people in our county. And so $600,000 is a tremendous amount of money for our county to be spending, and it was over $600,000, and it went up to upwards of $700,000 and $800,000 at one point. And by 10 years into restorative justice, we were at one point we actually hit $40,000 of out-of-home placement costs as opposed to $600,000 of placement costs. When it comes to But I think, to me personally, the thing that was more impactful than the cost savings. The cost savings are wonderful, and I strongly approve as a taxpayer in Yellow Medicine County. I'm very excited about the cost savings. But I think what was really, really fascinating is that the volunteers, the stories that I got coming out of Circle about volunteers who really invested in the youth that were participating. And so there were kids who didn't have driver's licenses because they were too young. They got invited to prom. And so volunteers would be the chauffeur for prom, right? Or the after-school mentoring and study sessions that were run at Jimmy's Pizza so that kids could pass their classes. And what I really come back to what keeps kids particularly what keeps people out of the justice system is having relationships. And so having somebody you can call at 2 o'clock in the morning to come get you or to talk you through the desire to use or having somebody who can help you get a job. What we've really found is that that's community. Our community is able to reach out and say, oh, you need a job reference. Oh, you need to earn some money. You are 11 years old, and you need to earn some money to pay off restitution of this victim. How is that ever going to happen? Well, me and all of my neighbors have leaves that you could rake, right? And so we're going to hire you, and we're going to get you to be able to contribute towards your restitution in a meaningful way so that you have that accountability. So what really, genuinely, when kids feel like they're invested in their community and their community is invested in them, they're much less likely to commit crime. And it's really an impressive, if they're the kids who cleaned off the graffiti under the bridge and their friend comes along and wants to re-spray paint it, they're like, no, I did that, I cleaned it, right? And so they're just much more likely, and they're holding each other accountable. And it returns to a day when people in the community felt like they could say, hey, knock that behavior off. And it empowers community to reach out to the children and not sit back and just let things happen.
Thank you.
I don't know if that answers your question, but okay, thank you.
Helpful. Thank you.
Thank you, Ms. Sealing. Chair Becker-Finn.
Thank you, Chair Latz. And I just wanted to point out, whenever I hear savings on out-of-home replacement costs, what I hear is generations of trauma that have not occurred to a family. And I know that as, I hope you all know on this committee, the disproportionate impact on our Native families of out-of-home placement. And so whenever I hear that, it's not the savings. I know that that has reverberations for not just for that child, but their parents and their siblings and everyone in that entire family. So the savings really is much more than the dollar amount. And I just wanted to point that amount, that like the dollar amount is great. Obviously, we're finance committees, but the actual preventing trauma from occurring to families in the first place should absolutely be a top priority of all of us. And I thank you for the work you're doing in Yellow Medicine County. It's really incredible.
Thank you.
Senator Umu-Verbaeten.
Thank you, Mr. Chair. I would just want to thank everyone, all the testifiers, Senator Seeberger, especially for sharing your stories. It's nice to see you, Mr. Burnside. I'm familiar with your work, so happy to see you here at the committee. I'm very supportive. I was one of the co-authors on the Senate side, and this is sort of a question for you, Representative Weiss, and perhaps the other House members, but just if you could talk about sort of in putting this budget together, the balance of prevention, right, and really emphasizing that and putting that in context with, the other funds that we're spending.
Am I allowed to talk? I'm just going to go for it. So yes, I would love to talk about that. So I've spent the last couple of years talking to a lot of experts in youth justice and trying to understand, like, where do we need to be making our investments? Like, how can we be strategic? How can we make our youth systems more just? And everyone has universally said that what we need to be doing is investing downstream. We need to be looking at prevention and intervention as the main investments that we're making in youth justice. So there is this temptation to look at, how can we, and I think we obviously need to be looking at the full spectrum of youth justice and children who are already involved in our criminal legal systems. But the temptation is to look at, like, oh, these children are a problem. How do we solve that problem? How do we, like, better lock them up? And we need to resist looking at the downstream investments as the only way that we can strategically, effectively invest in youth justice. And legislation like this is the way that we can really make an impact. And I know that's something that my community and everyone that I hear from really wants to focus on. So I'm very passionate about this approach to youth justice.
Senator West.
I don't think these are working, but I'm going to talk in it anyway. Thank you so much for bringing this, and thank you to my colleague, Senator Seeberger, for sharing such a deeply personal and touching story. And I'm really sorry that happened to your son and to your family. What we know about kids is that often behavior is speech. Often kids use behavior as their way of communicating. They do not have fully developed executive functioning and frontal lobes. We know that they are impulsive. And when you add on top of that kids who have high ACEs scores, who have experienced trauma in their lives, our approach often to behavior, especially for our young people, is just not appropriate. And what it does is it imposes additional trauma by getting them into a system that is so high, that includes so many more BIPOC kids, because they get caught up in a system that doesn't recognize trauma and the impact of trauma. And we know that when the ACEs study, the Adverse Childhood Experiences study, was initially done, they didn't include things like racism. And I think what we know is that we probably need to revisit what gets included in that sort of assessment of kids, that not only looking at neglect or abuse or parents who may be incarcerated and some of the other, the 10 factors for that study, but to look at as an adverse childhood experience, as a deeply adverse childhood experience, the impact of racism, the impact of poverty on kids' lives. And what you were describing here is an alternative that actually addresses the problem. It helps kids learn how to regulate themselves. It helps them learn how to understand the impact of their behavior on other people, which is really difficult for kids under the best of circumstances. But it also teaches them alternatives to that behavior. And so I could not support this more. This is incredibly important work, and I thank you, Representative Feist, for bringing this, and I thank our testifiers for bringing your real-world experience here. And this is really the approach that we should be taking with our young people, but I think also that we should be bringing this also to the adult world as well.
Thank you, Representative Feist, and to your testifiers for coming here today and sharing the information with us. Appreciate it.
Thank you.
Representative Frazier.
Thank you, Mr. Chair. I got a few here, so I'll start with the first one, House File 2956, which is modifying composition of the Minnesota Sentencing Guidelines Commission. You know, we established our guidelines commission back in 1978. And most recently, we've been working to ensure that commission reflects what is happening in our current times. The commission was established to ensure that our sentencings reflected the severity of the crime committed and convicted of, but also to ensure that we don't have any disparities within the way those sentences are doled out when someone is going through the system. The reason I'm bringing this bill this session is because our Sentencing Guidelines Commission is going through kind of a review of all of their policies and rules, and I thought this is a good timing to also take a look at the makeup of the board and to add a couple of more voices. And what it does is it adds 2 new members. One of those members would be someone that has an academic background in criminal justice systems and reforms or modernizing things with that point of view. Then also someone that has been a victim within and incarcerated within the system and have that voice on the board as well. I think that Minnesota, in many ways, has always been leading in this type of work, and I want to make sure that we continue to lead in this type of work. And as we continue to look at things in our state, we have a state that is, it's a tale of 2 states in many ways. One state, we're great. We're ranked in the top 1-5 or top 1 through 10 in most situations. But then when you often peel back and pare down and look at things segregated on data from particular demographics, whether that be gender or race, we tend to rank in the lower bottom part of that within the states in our country. And so this Guidelines Commission their specific job is to make sure that we don't have those disparities within our Sentencing Guidelines Commission. So that's why I'm bringing this bill, to ensure that we have those voices, to be able to make sure we don't have those particular disparities, and that we continue to lead and be a model for how things look within our state, and be a model for the rest of the nation. So that's why I'm bringing it.
Any questions or comments? Senator Umufer-Baden.
Thank you, Mr. Chair. Thank you, Representative Frazier, for bringing forward the bill. I know that Senator Mohammed carried this on our side and would want me to speak in support of it. I also co-authored, and I think it's just creating a commission that is going to better speak to the experiences of our folks and criminal justice system. So absolutely in support. Thank you.
Thank you.
All right, Representative Frazier, your next.
House File 1083 is expunging records for mistaken or stolen identity. This one was thinking it's pretty straightforward. This bill has been around for a while, so I'm hoping that we can get it across the finish line now. Many of us sitting at this table, and probably many of us sitting in this room, probably have had a situation with stolen identity or know someone that has had a situation with stolen identity. It has been something that has been trending even more frequently now as more folks are engaged on the internet or social media. And what this bill would do, if we put it into law, is if you are someone that has had a situation of mistaken or stolen identity, and there's been a charge or a conviction, once it has been determined that this has been a mistaken or stolen identity, that record would be automatically expunged without you having to go through any extra steps of providing a petition to do so. I think it's something that could help. During the hearing for this bill, we had someone testify that it was her sister that used her information and stole her identity, and she is still today having to go through extra steps when she is applying for anything in the social services realm, or also anything. She owns a farm, and so she applied to get a permit for a shotgun, and she had to go through extra steps to actually secure that permit. So this will go a long way in helping individuals out to clear their record back to the way it was before the stolen identity or mistaken identity happened.
Any questions or comments about this? Representative Frazier.
Thank you, Mr. Chair. House File 538, prohibiting police officer membership in extremist or violent hate groups. I brought this bill in my first year of my first term. Didn't think it'd be all that controversial, as we were, I believe, moving in a direction where we're trying to help rebuild the trust between our communities, particularly our BIPOC communities that have disproportionate engagement in our criminal justice system. And as we all know, that often starts with an interaction with our peace officers. Essentially what this bill does, it doubles down on that trust in the social contract that is made when you take that sacred oath to protect and serve the community. By saying that individuals that take that sacred oath cannot be engaged with or participating with extremist hate groups, because what we know is that those groups, they identify particular segments of the community in negative ways, and they target those groups. The reason this bill originated is because the FBI and intelligence groups within our country have identified these extremist groups trying to infiltrate our local law enforcement groups. And we want to ensure that the community knows that. We will not tolerate or allow individuals that are associated with those groups or connected with those groups to serve in our communities, to protect and serve in our communities. So this bill has been adopted in the rules provision by our Peace Officer Standards Board, and we would like to codify the law, again, to send that message to the community that we are steadfastly working hard in the legislature to ensure that we rebuild the trust between law enforcement and our communities.
Any questions or discussion? Representative Frazier.
Thank you, Mr. Chair. House File 2611, this is one that's close to me. I used to be a public defender in Hennepin County. And what this does, that we have a Board of Public Defense that consists of lawyers, but also consists of community members. What we're looking to do here with House File 2611 is to expand that board from 7 members to 9 members, and then to add more of a public voice. One of those members from that public voice would be someone that has practiced as a public defender within the last 5 years, or is a retired public defender, to provide that advocacy perspective on the board. And then adding another public voice as well, as this is the Board of Public Defense. They are interacting, engaging, and advocates for the public, and we think that it's important to have more public voices on the Board of Public Defense. And then lastly, to get back to Chapter 13, for those Chapter 13 lovers out here, we would make these meetings to have to be in compliance with the Chapter 13 open meeting law.
Representative Fraser, one question that has arisen in connection with this. It would change the balance on the Board of Public Defense to one which is majority appointed by the executive branch, as I understand it. And so, to me, it's raising at least some discussion around separation of powers and political control over the membership of the board. Do you have any thoughts on that question?
Mr. Chair, thank you for the question. Yeah, in terms of that, what it does is it adds one more public voice. And the reason I thought that was important, and it wasn't as concerning to me in terms of more appointments coming from the executive branch, was that this allows the public voice to be the leading voice on the board, for a board that is there to represent and advocate for the public. And I think that has been missing throughout the years. And I thought it was important to have that voice. And in the conversations I've had with community members and advocates, they agreed that it was important to have this voice. One more public member on this board to allow for that voice, to ensure that that voice is heard.
I do have some concern about the separation of powers issue. The Board of Public Defense has some independence, but it's part of the judicial branch. And having the governor have the majority of the appointments on a judicial branch subsidiary, if you will, to me raises some serious constitutional questions and policy questions I think we need to flesh out. Chair Becker.
Yeah, and I've heard that argument before, but I'm wondering if you could flesh out, it's like we throw around like, oh, I have some constitutional concerns, or I have some, separation of powers concerns. Obviously, the Chief Justice is appointed by the governor, so there's some kind of that give and take already within the system. And I'm just wondering if you could just flesh out a little bit more, point to what you're thinking as far as where those concerns are. So I'm just trying to understand your position a little better.
Sure. Well, all of our judges are appointed by the governor, but then they are independent completely from there. The governor has no formal authority or responsibility or oversight connection with any of the judges in the state after the appointment is completed. The judicial branch itself operates completely independently of the executive branch and of the legislative branch, except subject to the laws that we pass, and of course we fund everyone. So there's some inherent tension there. But if you have a governor that has a particular political agenda and is attempting to create outcomes in a judicial branch subsidiary or board by appointments, which is quite common by a governor, and they intentionally choose who they want to appoint, in part because they want to see certain makeup on the board. To me, it raises some questions about undue executive agency influence over the independence of the judiciary as a whole and of the Board of Public Defense in particular. So I'm not quite sure how that would cut.
Right.
What direction that might go. It might be good, might be bad, depending on the governor and the governor's inclinations and who they might appoint. I worry about that overall approach right now. It's not that there isn't representation from the executive branch appointments, but this would create a majority of appointments from the executive branch on a judicial agency. So that's what my concern is.
Yeah, thank you, Mr. Chair, for fleshing that out a bit, because I think, kind of the larger picture around public defense and the crisis that we've been in over the last couple of years, I just think that my concern actually is that the Board of Public Defense is too tightly tied to the judiciary, and making sure that there is some independence there, because obviously their role as a public defense, a public defender's ultimate role is different from that of the judiciary. And so I think that's always a little bit tricky. And, I think too, maintaining the, and this is the thing that we get to discuss in judiciary, that other committees don't get to really dig into that third branch. But I think, really being clear about, our Constitution, our state constitution says that our branches are separate and our jobs are separate. And that includes, us having the ability to set judicial pay, and that being a separate thing that's not dictated by either of the other two branches, but is a separate choice that we're making. And I think it is really important that we do, and I appreciate that we're able to have this in a more open way for the public to really think about what does it mean if our Constitution says all the branches are separate and that these are the roles and you can't give your role to any other branch of government. How does that actually play out in real time in the work that we do? So I appreciate that we're able to talk about this and have other folks sort of getting their wheels turning and think about it too. Thank you.
Thank you for that. Anyone else have any comments or thoughts on it? All right, thank you. Representative Curran.
Thank you, Chair. Happy to speak to House File 2290, or what we look at banning no-knock search warrants. So this is continued work from prior sessions. We know that Representative Hollins worked on this in the past. Senator Umu Verbaeten on the Senate side has carried this and worked with me on this as well, so I'm sure she'll want to speak to it. But just to introduce this concept a little bit, what we're looking at is taking the current language surrounding no-knock warrants, where we have somewhat of a prohibition, and we're looking to further narrow that language. And this comes from throughout session. We've initially, this was a total ban on no-knock warrants, and after conversations and through conversations in committee, our final version is allowing for a circumstance where an officer may be in jeopardy of violence or death, where essentially there's no other way that we could exercise this search warrant other than having a judge issue a no-knock. And so that was really the case when we talked about this in committee, that people seemed concerned about with the full ban, is how do we ensure that we're protecting our officers. And so this would be the situation that kept coming up, that concern. So that would still be allowed. But just to kind of go back on the history of no-knock warrants, we know that in the past, they've been typically used as part of the war on drugs. And so a lot of the work done prior to this session, and what Rep. Hollins had worked on as well, was trying to move this away from the war on drugs. And as we've talked with other provisions in our overall bill, that we know there are huge disparities when we're looking at tackling crime related to drugs. And so currently, a no-knock can't be used where the crime is solely for possessing drugs. And so this would further limit that. And I just want to point out too that the National Tactical Officers Association is also in favor of significantly reducing the opportunity to use a no-knock search warrant. And their opinion on this is that when considering the priority of safety and life, it's difficult at best to justify or defend a no-knock warrant service. Lessons learned over many years and our desire not to repeat our past mistakes are the foundation for our position. That's something that really speaks to me, and I highly agree with that assessment. And I know that there's probably a variety of situations that folks have come up with where they think we might need a no-knock application. But I still believe the fact remains that exigent circumstances are truly those situations where we may need to have public safety enter a dwelling without a warrant. And in those cases, we don't need a search warrant, and we don't need an arrest warrant to go in and save people when there's an emergency. So I really think what we have here is a really good compromised language that we've had with all kinds of stakeholders up to this point, and I welcome any questions that the committee has.
Representative Curran, speaking of the stakeholders, is this a Peace in the Valley proposal, or are there still stakeholders that are uncomfortable with it? Where are we at?
Thank you, Chair. So no, this is, we have a letter here from a few of the police, the MPPOA, and I believe it's along with the Chiefs Association as well. And I'll say that we have some disagreements on the language specifically. I believe our goals are still the same. What I'm hearing from some of the law enforcement organizations is that this is a tool they do not want taken out of a toolbox. And in my opinion, we can we can look back, and as Rep. Frazier was saying, you know, when we know more, when we know better, we do better. And I wholeheartedly believe that, you know, when we learn from our past and we look at the wrongs that have happened, we can't right those. We can't bring family members back. But what we can do is try to rid our future of regret. Where we had an opportunity to fix something that could have saved somebody, we can look back and say we did our work and we did it well and we saved that person. Overall in this body, unfortunately, that's not true. Where in the past we did have the opportunity to pass this, it didn't pass, and months later we ended up with a community member who was dead for no reason whatsoever. So, you know, I just want to really make sure that we're looking at all possible outcomes here. I recognize that leadership in certain organizations may not agree, but I will say that when you talk to boots on the ground, that's not necessarily the same opinion as maybe the one or two or three people who might lead certain organizations.
Representative Kern, I'm still a little bit unclear. Where is the MPPOA on this? You mentioned a letter from them. I have that letter.
Yeah, so they're opposed to the language as it stands today.
And you mentioned the Chiefs Association. Where they on it?
They had a similar stance in committees. They had a joint letter in opposition to the no-knock ban, but they did not. They didn't show up to testify, or they didn't wish to testify in person. But they did submit letters against this bill in both committee hearings.
And do you have any input from the other stakeholders that you can share with us?
I had meetings with a couple of different police chiefs. Rep. Moller and I have met. We met with some of our representatives who have kind of gone back and forth on this issue as well. And so what really got us to this point is talking with folks who were uncomfortable with a full ban and sort of making that provision in there so when we can show to a judge that there's no other way to execute this warrant, we need to have a no-knock, it's the safest way to do it, that will be allowed. And so that, you know, when I talked with one of the representatives, he shared that with his police department. They were really thankful for that change.
I'm sorry, you're talking about one of the state representatives?
Yeah, one of our state
Okay.
yeah, one of our state representatives
As opposed
shared
to a
that.
representative from an organization?
Correct,
Just to
correct.
clarify.
Yes, sure. So one of our state reps had gone back and shared, you know, our new language that we recently adopted, and that had a positive impact. So, you know, happy to answer further questions, but I know this is something that you know, folks tend to just have some disagreement on. I will say that when we're looking at the letter from MPPOA, that you know, they're looking at the policy goal of the statute as to preserve evidence and protect those executing the search warrant as well as the public. And I agree with most of that. But what I don't agree with is the way that our current statutes are written. It allows for us putting the preservation of evidence over the preservation of life. And that's where I have a large disagreement. And that ties directly to our Fourth Amendment constitutional rights against undue search and seizure. And so I really see this as a constitutional issue as well as a safety issue. I do see this as a safety issue for law enforcement as well. And I think the further we limit the scope of this tool, it is safer for the public and it is safer for law enforcement.
Any other questions or comments? Senator Hoover.
Thank you, Mr. Chair. Thank you, Representative Kern, for just leading this work over on the House side. And I think your voice as a former police officer yourself has been just so crucial in this process. I don't think I could have said it better than preservation of evidence over preservation of life. And I hope everyone is aware that a no-knock warrant is how we lost Amir Locke, and I know his family has been here advocating for this legislation. I really don't want to see another family have to go through this. I think there's immense urgency to get this done and do it right, and you've made changes along the way, and I'm I'm really pleased with where this is at. We'll support this as a conference committee.
Chair Moller.
Yeah, thank you, Mr. Chair, and do want to thank Representative Curran for all her work on this and the information she mentioned from the National Tactical Officers Association. It's a really compelling letter. We will make sure that that's included in the packets that you receive tomorrow, because they really talk about the history of what's changed and to why we used to do these and why they recommend, frankly, against these unannounced entries for the safety of both the people inside and the law enforcement officers who are executing them. I will also note that we heard from Representative Pinto on the House floor, and I verified with him that St. Paul has not used an unannounced entry, no-knock search warrant in 8 years. So that's a pretty good history to be aware of. And, just again to reiterate that this doesn't impact those exigent circumstances. So people police responding to a 911 call or something happening at the scene where they need to go in right away, those are still allowed. This doesn't change with this bill. And I'll also just say, too, the language that Representative Curran talked about, where we really tried to think about that narrow situation where it might still need to be a tool, was amended. We added that on the House floor. And you may not be aware, we debated this bill for about 11 hours, the entire bill. And so we're all a little tired still from that debate. And I'm looking forward to talking to the law enforcement groups about that change. And I know Representative Curran is open to that as well, because we really haven't had a chance since we made that change to talk to those specific organizations about that language. So I'm looking forward to having continued conversation about that. Thank you.
Chair Becker.
I thank you, and Chair Moller hit the letter I was going to point to as well, but also just want to lift up that this is a priority and has been a priority for community members throughout the state for many, many years. They may not reach the level of designated stakeholder, and they may not have a paid lobbyist and a letter on letterhead, but I know, and I've continued to hear from my constituents, I know members of our caucus have continued throughout the state, rural Minnesota, suburbs, urban, everywhere, from actual community members who remain concerned about this and want us to change things, and would encourage folks who didn't at earlier points listen to the testimony from Amir Locke's family to go back and bear witness and listen to that testimony. And I think I just want to make sure that we're not, if we get into back and forth about which group said which thing at what time, I just want to be clear that there are members of the community, our constituents who want to make sure community members are safe in this way. So I just wanted to lift that up as well. Thank you.
Thank you, Chair Latz. I'd just like to point out, I read this letter from MPPOA, and it talks about the preservation of evidence. And again, I'd like to underscore, we should be talking about the preservation of life and safety. And then I'll note that the city of St. Paul, our second largest city in our state, 8 years have not used these no-knock warrants. I have not seen data or an outcry or a scream that says in those 8 years they have been unable to secure evidence, or that officers have been unusually harmed when they're carrying out their duties to protect and serve the community. I think that is something we should really kind of focus on when we're thinking about are officers actually still able to do their jobs versus this taking this tool away and they cannot do that, and I don't believe that is the case.
Like so many other issues, we have to find the right balance between legislating broader standards or requirements, but leaving enough discretion to deal with individual circumstances. And the fact is, nothing that we do here will ever completely prevent the tragic loss of life under certain circumstances. We just can't foresee all of that, and we can't legislate well enough to provide guidance as police officers are interacting with members of the community in every circumstance and dealing with individual human behavior. So we'll have to struggle to find the right language to see if we can find a way to make this work. I look forward to looking through the exact language and having those further conversations with stakeholders. I use the term stakeholders broadly. So not just organizations that are represented by executive directors and lobbyists here. I do understand they are here on behalf of organizations, meaning they are speaking through whatever their processes were for selecting representatives. They're speaking on behalf of all of their membership as a collective whole. Doesn't mean it represents the views of every member in any organization, of course. I respect those voices, and I respect the other sources of community involvement and communication as well. And we have to figure out, under what circumstances we agree or disagree with what we're hearing. So this will be a good conversation for us to have as we work through this. So thank you for bringing this forward. Representative Kern, fines and fees in Ramsey County.
All right, another exciting controversial bill in front of us here. House File 1414, this is something that Chair Becker-Finn has been trying to carry and graciously turned over to me. This is basically correcting where fines and fees go between municipalities, counties, and the general fund. So currently, municipalities in Hennepin County receive 80% of money collected, and then the balance goes to our general fund. St. Paul receives 2/3, but other municipalities in Ramsey County receive 50% of the money collected from fines and fees, with then the balance going to the general fund. So what this bill does is brings the other municipalities within Ramsey County in alignment with St. Paul, where the city or the municipality would receive 2/3 of that fine instead of 50%, with the rest going to the general fund.
Representative Kern, what's the input from the county board, the city of St. Paul, other cities? I assume the other cities would prefer this. What do you hear from the other government agencies that are affected?
Yeah, I haven't heard anything negative from anyone. I don't know if Chair Becker-Finn can speak to in the past, but of course, my communities that I represent as suburbs of St. Paul are definitely pleased with this language.
Chair Becker-Finn.
Thank you, Chair Latz. Well, and just to be clear, every other city throughout the entire state gets at least 2/3, and the only cities that do not are suburban Ramsey County cities. And I've been carrying this for years. It's a very small amount. It's just a basic fairness thing. Nobody's really been able to tell me exactly why this was done when it was done. It was actually brought to my attention by this city manager of Little Canada, who was just sort of like, it's not a lot of money, but like for a smaller city, $30,000 a year is $30,000 a year they're not taking from their taxpayers. So I've never had any negative feedback from anyone in the years I carried this previous to this session. Just hoping this is finally the year we can get this $91,000 across the finish line.
This doesn't affect our budget, does it? All right, any questions or thoughts on this proposal? Well, members, I think this is a good time for us to take our lunch break. So we're going to recess. The Senate has floor session at 2:00. And so does the House, I understand. So I guess we'll stay in communication, and we'll hope to reconvene after the last body is done with the floor session. We all know we're all coming back for the joint convention tonight. I definitely want to make sure people have time to eat dinner before that, so we don't have members all cranky on the House floor during the regent selection. So for right now, we are in recess.